everyone. Happy Monday morning. I am Carol Williams with Williams Immigration, and we are back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So, I like to dive right on in. So, the first thing I want to talk to y'all about are biometrics that are still being suspended. So, there are certain applications where the Immigration Service right now is not collecting the biometric fee, and they are not requesting that individuals come in to the office to have their 10 print fingerprints taken or their picture. So those applications are their dependent applications, so your H4s, your L2s, and your Es. Initially, this suspension of biometrics was temporary, and it was to last until May 17th of this year. But they have extended that deadline. So the new deadline is September 30th. So if you are filing a dependent extension or a change to this new dependent status, H4, L2, or E, just beware that the biometrics, by and large, have been suspended. So USCIS is not collecting a new photograph and new fingerprint information. They will use what they already have on file. That goes also with the background checks. However, there's always a however or a but. This is completely discretionary. So if you do get a biometrics notice and you're pretty sure that you are, part of the class of individuals that doesn't, that you didn't send in the biometric fee, make sure to go to the biometric appointment. That means they want to actually take your biometrics. So along with that, if we really should now all be sending in separate checks for the filing fee as well as the biometric fee, 2 checks. If you send in 2 checks and the Immigration Service determines that they are not going to take your biometrics, that you're part of this wide range of people where they're not going to take your biometrics, they will return that biometric fee check to you, and they will continue processing your application. But if you send in one combined check with the filing fee and the biometric fee, the Immigration Service will return your one check to you and the entire application, forcing you to then refile the application. So that could have deadline and or status implications depending on when you filed. So just make sure that you are filing with separate checks for the filing fee and the biometric fee. So again, that suspension is now extended from May 17th to September 30th. And so that is good news for us. The next thing I want to talk about are some states have now started issuing mobile or digital driver's licenses and state-issued identification cards, which is great. Like, we all love technology. We're all sort of clued into technology. Specifically, Arizona, Colorado, and Maryland, your mobile driver's licenses are now accessible through your Apple Wallet, which is great, right? That's just one less thing in your wallet, one less thing you have to worry about losing. It's all digital. However, again, there's always a however or a but when I'm speaking with y'all. However, DHS through USCIS has not come out and specifically said that they will accept the digital or mobile driver's license or state-issued ID for purposes of the I-9 verification. So if you are an employer in Arizona, Colorado, or Maryland, and I'm sure there will be other states that are adding and creating their own mobile or digital driver's licenses or state's ID, beware that we have not received any official notice that DHS will accept the digital or mobile driver's license. when it comes to the I-9. So my incredibly conservative advice at this point of this new piece of tech for us is to not accept the digital or mobile identification card or driver's license as a valid List B document for purposes of I-9. The individual is certainly welcome to present, if they choose, the standard physical card or any other document that meets the List B requirements that are listed on the form. And I'm being extremely conservative in this advice right now, this recommendation, simply because the Immigration Service has not affirmatively said that they will accept mobile or digital driver's licenses or state issued IDs. And so what I don't want is for companies all of a sudden to be non-compliant with their I-9, with their I-9s. So I would like to think that the Immigration Service will sooner rather than later come out and say, yes, we find these digital or mobile driver's licenses acceptable, but as of right now, they have not. So we just want to be, aware of that. Technology is great. Sometimes it takes the government agency a little bit longer to kind of catch up with the speed of the private sector technology that's coming out. But fingers crossed, hopefully they will come out with some guidance for us sooner rather than later that we can accept the mobile driver's license. But as of right now, they have not said anything affirmatively. The next thing I want to talk about is the medical exam. So when you're applying for a green card, everyone that applies for a green card is required to have a medical exam from a U.S. government approved doctor or they call them civil surgeons. And that doctor / civil surgeon must do the exam, write up fill out the form, writing up the report, and then sign it. As of now, that report no longer needs to be signed within 60 days of filing your application. The Immigration Service previously made that a very tight 60 days. Hopefully, it was supposed to lead to more efficiency with getting those applications filed and the validity of those medical reports, but they haven't really seen that happening. So they have now done away with that. So our medical exams no longer need to be signed by the doctor / civil surgeon within 60 days of filing the application. The medical is, however, valid 2 years from the time the doctor or civil surgeon signs that medical. So as long as the green card is adjudicated within 2 years of the doctor signing off on the medical, you will not need to get a new medical during the course of the green card application. But if that medical expires, if that 2 years runs out from the time the doctor signs and the green card hasn't been issued yet, then the USCIS will absolutely send a request for further evidence requesting a new medical be done. So work very closely with an attorney to figure out the timing of getting your medical done, getting your application submitted. Okay. And the last thing I want to talk to you all about today is a national interest waiver tip. Last week we talked about who qualified for the national interest waiver. This week I want to give just a tip on how my office specifically handles national interest waivers. So we know that national interest waiver is a green card category. It is a way for individuals to obtain lawful permanent residence or receive a green card in the United States. And in order for that to happen, individuals can either be sponsored by an employer or they can sponsor themselves, what we typically call self-petitioning. So the requirements are that the proposed endeavor of the individual must have both substantial merit and national importance. We need to show in that application also that the beneficiary is well positioned to advance this particular endeavor. Once they receive their green card, they're going to stay in that profession and they're going to advance it. They're going to bring it even more, they're going to bring it forward more so than what it already is. And that on balance, it is beneficial to the United States to waive the requirements of a job offer and thus the labor certification application. So those are the 3 requirements. The tip that we do and what I have for you today is that one thing that we do in our office is a great way to show that the beneficiary meets these 3 requirements is to submit support letters from well-respected people in their industry. High-level people in their industry, people that have been in their industry for a very long time. And so what I do is I work very closely with my clients as they come up with a list of colleagues. And it's sometimes people that they have maybe never even worked with, but these individuals know of their work because it is so well regarded within the industry. And I work with my clients very closely to have those letters drafted so that we can show how the beneficiary is really at the top of their industry and how they are well poised if they are granted a green card to continue in this particular industry and move it forward. And so also that, that their proposed endeavor has, and we can show that it has national merit, substantial merit and national importance. So that's a really key component to all of the national interest waiver applications that I file. And when I say support letter, it is more than simply confirming where somebody worked. So our support letters say much, much more than, John Doe worked at XYZ company from A date to B date. It is much, much more than that. It really goes into depth into what they did and how beneficial they were, and oftentimes where the author of the support letter sees the beneficiary going with their career and how it will be helpful. So that is my tip on the national interest waiver this Monday morning. If you have any questions about your employment or family-based immigration case, feel free to reach out to my office. We will get a consultation set up with you and have a conversation with you and see how we can help you. You can call us 954-903-1337, or you can shoot us a DM. We will certainly respond to those. And if this was helpful, feel free to hit like, hit share, and send it to a colleague or friend or family member that you think may find this information helpful. Have a wonderful rest of your Monday and a great